Okay, I would like to call the September 14th, 2017 Board of Adjustment meeting to order. Clerk, will you please call the roll?
Don Cloud.
Present.
Matthew Bailey.
Present.
Leah Montesa.
Present.
Joseph Kovacs.
Present.
Michael Hanger. Gregory Hammer.
Present.
Joy Breathley.
Present.
A quorum has been met with 4 regular members present and 2 alternate members present.
And I told you not to read this, but if you will have to do the minutes tonight, and there'll only be 5 members that will be doing that. So if you can pick between Mr. Hammer and Mr. Braithwaite, which one will be on the sitting with the board tonight for that. But everyone will need to stay for the training. So just take a pick as to whichever one you want to be the official person to vote on the minutes for the meeting, which they didn't attend.
Mr. Braithwaite, will you please join us? Thank you. Okay, so that all I can say? I have to say. Okay, I didn't know about that. Our new board members are Matthew Beatty, representing District 2, Poplar Branch Township, Joe Kovacs, representing District 5, Mayock Township. Alternates will be Gregory Hammer, representing District 4, Mayock Township, and Troy Breathwaite, at large, Mayock Township. Clerk, will you please administer the oath of office to our new board members?
I'd like the new board members to come up to the front, please.
Mr. Kovacs, you can probably
Stand right here.
another Bible.
Okay. Here, we can do it. We can do it all right here. Read, if you all want to left hand on the Bible, and raise your right hand, and repeat after me with the name after the pronoun I. I do solemnly swear that I will faithfully execute the duties as a regular member of the Currituck County Board of Adjustment and will, to the best of my ability, preserve, protect, and defend the Constitution and laws of the United States and of this state, so help me God.
You're welcome.
Oh, can I get y'all to sign these papers here and then I'll notarize them? Let me bring Joe his.
Is Vivian still on the board? No. You're doomed. Just give it up. 3 times the charm.
Sit up here.
In just a minute, Ms. McLeod is going to ask for nominations for chair and then vice chair following the chair. Once the chair is elected, that chair will actually ask for the vice chair. But the reason Ms. McLeod's doing it, she's not the current chair, but the current chair is off the board, and so there isn't a chair. So the kind of goes down the line. Ms. McLeod's the most senior member, so she's doing the chairing until a chair is elected. But all of you are relatively new, so this is a new process, but it typically comes up every January per the ordinance to elect a new chair and vice chair. So the process, she's going to ask for nominations and then ask if there is a motion to approve the nomination. And we'll go through that until we pick a chair. And then once we pick a chair, if it's Ms. McLeod, she'll stay in the chair and keep going to pick the vice chair. And if it's someone else, then they'll take over the chairmanship for the rest of the meeting. So I just wanted to give a little background before she goes into that, and I'll do my best to help guide her through that.
Do I have a nomination for chairman of the board?
I nominate Donna McLeod. She's glaring at me.
All in favor, say aye. Whoops. Do I have a motion to approve the nomination?
A motion.
He did. He said second. That's
I
fine.
seconded it.
He seconded. All in favor, say aye.
Aye.
All opposed, say nay. Motion carries. Do I have a nomination for vice chairman of the board?
I nominate Zia.
I don't know enough about it to be vice chairman. I don't think I had enough experience on the
Well,
board
guess
to be
what?
vice.
We can learn together.
Oh, please, don't, no, I can't do it. I just can't.
Well, and let me explain the roles of the chair and vice chairman. The chair and the Board of Adjustment really manages the meeting. They don't have any other special role outside of the meeting. They manage the meeting, and they control the parliamentary procedure and sometimes come to me to address those issues. And the vice chair would be the person behind them in line if the chair's not here, or if the chair has to recuse themselves, but they don't have any particular duties either beyond the chair.
Add to that is the chairman that they do have the authority to approve a subpoena if we ever get to the, if we ever
Yeah.
need that. That would be part of, staff would come to you and say we need a subpoena for certain things if we ever get to that point of any of our cases.
Yeah. And staff typically has gone through me to help guide the
The
chair
chair
through
vote?
that process.
Right.
Yes, the chair votes, the chair can make motions, the chair is just like any other member of the board in terms of their actions, and so is the vice chair. The only difference is that the chair is the one who manages the meetings, and the vice chair would manage the meetings in their stead. The chair is also the person that signs the final orders that come out of your cases, but usually there's not too much controversy over that.
Can the chair be an alternate? I mean, the vice chair be an alternate?
No.
Okay.
So the vice chair has to be a regular member.
Can't do this.
I nominate
My husband's in a
Nancy Bailey.
nursing home dying from cancer. I cannot
So
give
we've
up
got
that
a
much.
so we've got a nomination for Matt.
Second it. He's young. Go for it, Matt.
All in favor, say aye. Aye. All opposed, say nay.
So you're going to be the vice chair. Okay.
Good. You'll enjoy it.
And so the next thing to do, Ms. McLeod, is Chair McLeod. is to approve the agenda.
Do I read, are there any changes to the agenda? Do I have a motion to approve the agenda as presented?
Make a motion to approve the agenda as presented.
Do I have a second to the motion? Second. All in favor, say aye.
Aye.
Motion carries. Did I read that?
It's okay. Legally, you don't have to be here to vote on the minutes. It's a strange thing that comes up, but this is the situation where it comes up every time. There's always going to be new board members, and there's always going to have to be a vote on the minutes of prior meetings when those new board members are here. And the way the law is that they get to vote. And one thing that works for this board as well as the other boards of the county is if you don't vote at all, your vote is, and you haven't been excused formally, then your vote is a yay vote. Something that you just need to know. It doesn't come up very often, but a few years ago, and the best story about this is a few years ago in Wake County, they had a completely new board, split between Democrats and Republicans, 7-member board, and 1 member was in the hospital for the first meeting about to elect the chair and the chairperson, which was a very important role on the Wake County Board of Commissioners. they fought for a while, and nobody could get past the deadlock of 3-3, so they, at some point, somebody went to the bathroom, and one of the other folks made a motion, and they ended up with a Republican chair and vice chair, I believe, because it was a Democrat who went to the bathroom, and their vote ended up being for the other chair. So it's not something that comes up very often, but it's a good story.
Go to the bathroom before you come to the meeting.
Definitely.
So I do this one too?
Yeah.
Good. Are there any changes to the minutes? Do I have a motion to approve the minutes as presented?
Motion to approve is presented.
Do I have a second to the motion?
Second.
All in favor say aye.
Aye.
Motion carries. Any old business?
Nope.
Board of Adjustment, new business, Board of Adjustment training conducted by the attorney for our board, Mr. Ben Gallup.
I'm going to go down here so I can look at y'all. And so that I can get right out the door when it's over.
I have a question before you start.
Absolutely.
You said that we will be electing new chairman in January, correct?
Yes, ma'am.
Okay.
So, the Board of Adjustment is the quasi-judicial body of the county. And the difference between, if you think of your branches of government, you've got your executive branch, your legislative branch, and your judicial branch. In county government, the county board and the county staff are essentially your executive branch. They're the branch that does things, that takes enforcement actions, that grants permits, and that does other things, deciding about contracts and the things that the county gets involved with. The County Board of Commissioners is the legislative body. So they do some executive functions, but they are the sole legislative body. They are the body with the power to make the ordinances for the county. And the ordinances for the county are the legislation for the county. Quasi-judicial matters come up both to this board and to the Board of Commissioners. But nothing that you will see will be anything but quasi-judicial. So when I say quasi-judicial, it's quasi because you're not judges. Otherwise, it's pretty similar to being a judge. You have hearings, you have sworn testimony of witnesses, you have evidence, and you take that evidence and you apply it to the type of proceeding that you're dealing with and to the ordinances that are adopted by the county, and you come up with an answer to a question or a ruling, essentially. Very similar to a judge in court does. If you go in for speeding, the policeman comes in and says, I swear he was going 58 miles an hour, and you say, I swear I was going 55 miles an hour, and the judge looks and says, I believe the 58 mile an hour, and the law says that the legislature passed says if you're going over 55, it's a violation of the law. I'm finding you guilty. You're doing the same thing. You're taking the facts, you apply them to the law, and you come up with a ruling based on that. Used to be that the Board of Adjustment, under the statute, the Board of Adjustment can consider three things. Conditional use permits, special use permits, same sort of thing, variances and appeals of administrative decisions made by the staff. In Currituck, the Board of Commissioners hears conditional use permits. So you don't hear those. When I started as the Board of Adjustment attorney here, this board heard those matters, and there was a lot more meetings that had a lot more items on the agenda. But currently what you hear are variances and appeals. Now, pull my little outline out here. So, a variance is probably typically considered the more complicated hearing that you'll have, although appeals can be complicated as well. But what a variance is someone is coming in asking you, telling you that they have an extraordinary situation that is so extraordinary that you should vary or change or manipulate some portion of the legislation adopted by the Board of Commissioners to allow them to do what they want to do. The simple case is someone has a property that, because of its shape and its peculiar situation, that to build a house, it needs a setback that's a foot different or 6 inches different from what the statute or the ordinance allows. And that's what you're there to consider. And when you're dealing with variances, you're going to have particular standards that have to be met. And the applicant is the one who has the burden of producing evidence to meet those standards. And the standards will be something that and let me backtrack. I told some of y'all I'd tell you who I was and what I do, and I guess I forgot to do that initially. But my name's Ben Gallup, and I'm the attorney for this board. I'm not the county attorney. Ike McCree is the county attorney. I just represent this board. That also means I'm not your individual attorney. It's rare, but occasionally things do come up related to boards, be it this board or the county board, where individual members have legal questions that relate to them, not to the board. And if you have a question that you ask me, and if it ends up being something that I can't answer because I'm not your lawyer, I'll tell you that. But it's really, really, really rare for that to be a problem. Most of the time, it relates to your board service here, and I'm the person who guides you through that. And what my job is you guys make the decisions. And because, the quasi-judicial concept, y'all aren't judges, so therefore you aren't lawyers before you were the judge, you don't necessarily have the legal background that I do, although likely most of you are much smarter than I am and can grasp it just as easily as I can. But what I try and do is, one, guide on the procedural aspects of what's going on so that appeals from this board to the Superior Court don't get turned around because of a procedural problem. And then I try and avoid guiding you in how to reach your decision, because I'm not the decision maker. You are the decision maker. Clearly, I have thoughts on what the decision should be. And sometimes I've watched boards come to a different decision than I would have come to, knowing what the law is and knowing what the background of the case is. But it's not my role to tell you what the decision should be or to even guide you in the decision. The limitation on my role there is that occasionally, or ends up being most times, I will try and get you into the area of the law that is at issue. The part where you have to make a decision, is it this or this? Because sometimes, particularly where applicants come without attorneys, it can go off in the left field very quickly, but the real issue is relatively narrow on most occasions, and I will try and bring you into where you're making a decision, but not guide you on what the decision is. The decision is your decision. Also, that's what I do when I'm here. Occasionally, there are questions that come up outside of the hearings about recusal or how to deal with someone talking to you about a case, things like that. And I'll get into that a little bit more later, but I'm also the person who you would call to walk you through that process. And going back to the fact that I'm the attorney for the board, and I sit with you, usually I'll sit over where Mr. Braithwaite's sitting. Or I sit wherever the chair tells me to sit, so maybe I'll be sitting up there. And it depends on how things are going and what the chair wants. But it's important, again, to recognize that I am not the county attorney. The parties that come before you will be typically an applicant versus the county. And county will be county staff, and Mr. McCree will represent them if he comes. Sometimes he comes. Some cases involve Mr. McCree, some cases don't. But if Mr. McCree comes, he will be representing the county staff and the county as an entity in front of this board. An applicant may come alone. They might come with a surveyor or an engineering firm, or they might come with an attorney. And they will be, just like a party, it's kind of like in a civil courtroom where there's a plaintiff and a defendant. You call them the applicant and the county. But it's the same sort of thing. There's always going to be adversity. Somebody says one thing and somebody says the other. Occasionally you will also have other people who become parties or who bring the matter before this board who have what's called standing, and they might not be that applicant for the permit, they might be somebody else. So you might have 2 or 3 parties in front of you. But the most common is that you have 2, staff and the applicant. And their role is that they will have their own attorneys if they deem it necessary and feel it necessary. I'm not here to help either one of them. I'm here to help you and to guide you into how to be fair and get into the area where you're making the right answers and taking the right procedural steps. So getting back to variances. Variances aren't remedies that you can't go and take an ordinance away. You can't just say an ordinance doesn't apply. They're a remedy that allows you to make adjustments for equitable purposes, essentially. For someone who the 4 standards are basically going to be that the ordinance causes them a problem as it exists, that the problem is not something that they created, that it's a problem that they didn't cause, that the problem is based on the land associated with their property, not purely economic concerns, and that the problem is peculiar to their property and not something that is a problem that everybody has. Everybody wants to build a bigger house. So coming in to ask for a setback change because you want to build a bigger house isn't the exceptional case that qualifies for a variance. But what we'll do is you'll hear evidence, and then you'll step through each one of those standards and see, and somebody will make a motion to say yes or no for each of those standards, and you'll take a vote. And if you get to the end of the 4 standards and they're all 4 yeses, they're all 4 in favor of a variance, then you have to grant the variance. If you get to the end of the 4 standards and 3 of them are in favor and 1 of them is against, then you have to deny the variance. Variances are also interesting because you're a 5-person board when you're sitting, and variances require a 4/5 vote on all in favor of the applicant on all 4 of the standards in order to qualify to get the variance. So occasionally what you'll see is that only 4 people will be here. And usually the applicant will say, usually we'll present to the applicant that, do you want to continue this to another time because only 4 people were able to come. You're going to have to get a unanimous response. And usually they will continue it to another date. Sometimes they go ahead and roll with it and and roll the dice with trying to get a unanimous 4-0 vote on variances. So shifting gears to appeals, the most significant difference between variances and appeals is that it only requires a 3/5 vote. So you don't have to have a 4/5 requirement for the variance. And what an appeal is staff makes decisions, such as granting or denying permits, such as issuing notices of violation to people who they believe are in violation of the county ordinances, and issuing civil citations to people who they believe are in violation of the county ordinances. So civil citations would be, you're going to have to pay this until you fix it. What people do, it's rare that you get a case where someone is granted a permit and then they appeal. Usually it's where they're denied a permit. And when permits are denied and they come to you, the question will be, under the facts, was the permit properly denied by the staff? And depending on what kind of permit it is, you can't hear all permits, but you can certainly hear zoning, and you can hear any other permits that the ordinance directs to this board. Building permits would not come to you, but zoning permits would. I think we've seen flood permits and flood appeals. I'm not sure what else the Currituck ordinances direct come to this board. The primary ones you'll see is a zoning permit issue. So there'll be some provision in the zoning code, in the zoning ordinance, that staff says they didn't meet this provision, so they don't get their permit. And that the applicant says, well, you're reading it wrong, we do meet this provision, or the facts that you got are wrong, and these are the facts, and we do meet this provision, and you're going to have to decide, just like the staff decided. You sit in the shoes of the staff, essentially, and you get to decide, okay, under these facts, does it meet the ordinance, and should there be a permit granted, or was it correct to deny the permit? Same thing for a notice of violation. Somebody has something going on their property, the county issues a notice of violation and says you're in violation of ordinance provision XXX because you're doing XXX, stop. Somebody says, I'm not doing XXX, or I'm not in violation of XXX because of whatever I'm doing. I'm going to appeal. So that comes to you. And again, you take the facts, you look at the provisions of the ordinance that are at issue, and you decide whether or not staff applied the facts correctly to the ordinance. Sometimes they have, sometimes they haven't. Nobody's perfect. And while you may wish to rely on our very dedicated and excellent staff here in Currituck, sometimes things are a close call. Sometimes the facts that get presented at the meeting that you have to use to decide aren't sufficient to meet what they think might have met the ordinance. Whether that's because they didn't bring somebody to testify, or they don't have some information, or they simply made a mistake. Sometimes that happens. But what you have to do is listen to what's presented every time and apply that to the ordinance yourself and reach a conclusion, just like they would have done sitting in their office downstairs or upstairs. And just like them, you can make mistakes. Nobody's perfect. But I think that's why there are 5 of you who sit up here at a time. Hopefully, I think that the legislature and everybody else is hoping that if you put 5 heads together, you can't make it look so much worse. But that's an important part of appeals. And it's an important thing to think about is staff is very helpful, but you need to avoid asking them too many questions ahead of time, because they're going to come to you to present the evidence and their position, and you don't want to be too influenced ahead of time. You want to take that into account at the meeting and deal with it then. But they are, as far as when the meetings are, when you need to show up, what you need to do, who you need to call, when you need to call me. Staff's very helpful for that. And in general, I don't think that they have any issue with the fact that they are a supplicant. It's interesting for me, and it's been interesting with me for different staff members at different times about the fact that I can't help. There are times when I've had knowledge from a legal perspective of how to fix a problem if I were representing the staff. But that's not my job. My job is to guide you, staff, and the county attorney's job, and the county's job is to bring the necessary evidence and information to you. So let's talk about hearings a little bit. You may have been in the courtroom a fair amount. I don't know. Has anybody been in the courtroom for any reason for a fair amount of opportunities for surveying stuff? You testified as an expert, I assume. And I'm sure everybody's watched Law and Order. Law and Order is actually not too far off from reality as far as TV shows go. But you see people making objections about evidentiary issues, and this and that comes in. You read about that in the news. This board tracks the rules of evidence, but you're not bound to the formal rules that a courtroom follows. There are certain things that you are bound to. You've got to have competent, sworn evidence to make your decisions, and that has to be presented here at the meeting. You shouldn't be making decisions based on evidence that you've seen or received outside of the meeting, or that wasn't sworn, that wasn't presented by someone who was sworn. And when they say competent, I'll try and see if I can explain that any better. Okay, the term competent evidence shall not preclude reliance by the decision-making board on evidence that would not be admissible under the rules of evidence as applied in the trial division of the Superior Court. So what I'm saying is competency isn't driven by the formal evidence rules. If the evidence was admitted without objection, or the evidence appears to be sufficiently trustworthy and was admitted under circumstances that it was reasonable for the decision-making board to rely on it. So a lot of these hearings, nobody knows to object. So they don't object. And sometimes what you get into evidence is, well, I got a letter from the DOT, Randy Midget, who's an engineer over in Elizabeth City for the DOT, and it's right here, and he says this. And if nobody really questions that that's what it is and nobody objects, then that may be admissible evidence. Whereas if someone objects, it's likely going to be considered hearsay because that person, Randy Midget, is not here to testify as to what he said. It's someone else saying what Randy Midget said. So you got to have competent substantial evidence. So substantial evidence is that which a reasonable mind might accept as adequate to support a conclusion. So that just told you absolutely nothing. As a lawyer, it tells me pretty close to absolutely nothing. But substantial evidence to me is that it's real. That you can listen to it and say, well, that means that this conclusion is here. Not, well, it's real likely that if that happened, then this is right. It's, this means this. So it's a hard standard to follow without evidence being in front of you to determine whether or not that's the standard. But that is what the standard, based on the ordinance and the statute, is that you have to follow. Sometimes you'll hear in this board from expert witnesses. And in certain cases, let me try and explain that two types of evidence that are primary in a courtroom. One is evidence that someone has personal knowledge of, someone saw it. And the other is opinion evidence provided by experts. Occasionally, opinion evidence can be provided by lay witnesses. Sometimes, it used to be that in a courtroom, lay witnesses could provide testimony as to the value of their property. In some cases, they probably still can. Not all cases. But things like engineering, a lot of times a lay witness is going to get an objection for providing an engineering analysis because they're not an engineer. But if someone's qualified and goes through the steps to qualify themselves as an expert and provide you with an opinion on an engineering analysis or a surveying analysis, then that person may be able to give that testimony. You're typically not going to see experts really providing expert testimony without somebody representing the party as an attorney. So it's usually, I get to guide you a little bit, but the attorneys are doing the right things and fighting about the right things. So that's not that big a deal. But the statute is important in that it says competent evidence does not include opinion testimony provided by lay witnesses in any of the following. That the use of property in a particular way would affect the value of other property. So if there's an ordinance provision that says you can do this unless it will negatively affect the value of other property, and that's what's at issue, then somebody's going to need to bring an appraiser to testify to how it affects the property value. The owner can't testify that it affects his value. The neighbor can't testify that it negatively affects his value. You've got to bring an appraiser. Another case is traffic engineering. The statute specifically takes traffic engineering out of the category of things that a lay witness can testify to. And that's pretty common. I think this statute was updated 4 or 5 years ago, and prior to that, it really wasn't uncommon for somebody to come in and say, I don't want this next door to me because it's going to put 40 more cars on the road in front of my property. Well, somebody got a hold of the legislature and said, that's really causing us a problem in our development, so the legislature stuck it in that statute, and so now you can't do that. You have to have a traffic engineer do it. And then the third is matters about which only expert testimony would generally be admissible under the rules of evidence. And that's backtracking to the engineering and things like that you just don't let lay people testify to typically. All right. So the next interesting area to talk about is what used to be called conflicts of interest. And what now is deemed to be an impermissible violation of due process. So it's easier to call it conflicts of interest, and that's what we'll consider it as. But this board, you're not an out-of-town judge coming from Wilson to hear a case. You all live here. And somebody who comes before this board is going to be your neighbor. They're going to go to church with you. They may work with you. They may employ you. And that's when you start to get into issues involving conflicts of interest. So the easiest ones are, if you're the applicant, you can't sit on the board. Okay? The biggest thing is if you're considering your own financial interest or your own official conduct, you can't sit on the board. That also stretches to your immediate family members. If it's your third cousin once removed, call me ahead of time and we'll do the analysis to try and figure out if it's a problem. Sometimes it's easier to avoid the problem by just asking to be recused, and usually you can do that. So the other big one is having a fixed opinion prior to the hearing on the matter that is not susceptible to change. So before every hearing, you're going to get an agenda packet that staff is going to have written up a fair amount of analysis and their perspective on the case. There may be an application in it that the opposing party has written up their analysis of the case. And what this is saying, it's not saying you can't read your agenda packet and have some idea of what you're looking at and what you're probably going to decide before you come in here. What it's saying is that you're not coming in with an open mind, that if the evidence does not match what's in the staff report, or the evidence leads you to a particular conclusion different than what you have read ahead of time, that you might not make a different answer. And the easiest way to look at this is, take, for example, somebody who wants something related to a sexually oriented business. Some people are going to have a moral perspective that it doesn't matter whether it meets every provision of that ordinance, I ain't voting for it. That's a conflict. That's the impermissible conflict of having a fixed opinion prior to coming in. That there are no facts, there are no laws, there is nothing that's going to change your perspective, that it ain't happening. And that's the easy one to see. And everything else in the middle is gray. But just having read the agenda packet and having some idea of, oh, well, the ordinance seems to say this, and the facts seem to say this, and they agree on that, that can't be right, or that has to be right. As long as you're willing to come into the meeting and say, well, maybe I was wrong about that. If you are wrong about it, if you want to change your mind, if you have an open mind, then that provision doesn't apply. It's where you just cannot possibly have the ability to change your mind. The next one is undisclosed ex parte communications. So, what are ex parte communications? We talked about earlier, they're parties. The county and the applicant. If the applicant talks to you and tells you something about the case, the easiest thing is if somebody starts talking to you about something that you can figure out, sometimes you can't figure out that it's coming to you until they've gotten 10 sentences into it. But as soon as you can figure out that they're talking about something that's going to come to you at this board, the easiest thing to say is, I'm on that board, I can't keep listening to this, and if I do, I'm going to have to tell them everything you told me. That'll usually get them to stop. If not, then what you have to do is you have to tell at the hearing everything that was disclosed to you. And that applies to county staff about the hearing too. It doesn't apply to county staff about what time do you arrive, do you need to be here, that sort of thing. But if you ask them any substantive questions about the case and they tell you their thoughts on it or tell you anything about it, then you need to be prepared to disclose that, because what this provision is trying to do is it wants every side to have an opportunity to respond to the facts that you're hearing from somewhere else. If you take everything just from inside the hearing, then everybody in here, both sides, get to raise their hand and object and bring their own evidence to tell you that it's not as you think it is. But if you start pulling from personal experience or personal knowledge or knowledge that a party has given you that the other party doesn't know that you've got, then that other party doesn't have the ability to respond. And that's where the due process violation comes in. That's where the issue becomes a conflict, because that other party doesn't have the ability to tell you that, well, when you rode by my house and you're looking at the property, that's great, I'm glad you did that, but you're looking at the wrong side. If you don't tell them that you did that, that you're considering evidence outside of the hearing, then they can't correct problems that or attempt to correct it. Now, what you may hear might actually be the true facts, but everybody gets an opportunity to present their side and to know what the other side has presented. So, if you get emails, bring them. That's it. Emails are a lot easier than oral conversations. If you get emails about the case beyond the agenda packet, then bring it and be prepared to put it into evidence and say, I had an ex parte communication. This was the extent of it. I'm disclosing it to cure this problem. So that's the beauty of this provision, is it's not ex parte communications that are the problem. It's undisclosed ex parte communications that are the problem. If you disclose them, you solve the problem. And then the next one is a close familial business or associational relationship with an affected person or a financial interest in the outcome of the matter. And that's kind of like what we discussed before. There's a lot of gray area there. If you think it's an issue, if you see somebody's name on there that is your best friend, that's probably going to be an issue. But just because you go to church with them, or just because you might have worked with them 22 years ago, that may or may not. It might take some analysis and some thought. There's a lot of potential gray area there, and that's a situation where, particularly if you see it ahead of time, that it's worth giving me a call to try and work through. And what may come up is that if you see something like that, we may bring it up at the beginning of a hearing, and I may ask you some questions. The parties may be able to ask you some questions, or raise an objection to you being on the board, and then the board will get to vote to either leave you there or take you off. What comes up more and more is that sophisticated applicants are delving into those conflict issues deeper and deeper beforehand. And what the statute provides is that they can object to your consideration at a hearing, and at that time, if we don't know about it ahead of time, then I've got to kind of on the spur of the moment come up with some questions, kind of like talking to a jury, and find out what the issues are, and then the board gets to vote to either keep you or not keep you on that hearing. And some of that may be whether or not you want them to keep you or not keep you. And sometimes you get in an area where you're just not sure, and it's just not, you feel a little uncomfortable, but you're not so uncomfortable that the law will probably make you get off, but you want somebody else to make the decision rather than you. And that's, sometimes that's how it arises as well. But those things come up. And for the alternates, the county's going to tell you, staff's going to tell you, because I think they pay y'all if you come, they're probably going to tell you to, if we got 5 people coming, then y'all don't need to come. My personal preference is that everybody comes to everything. And the next round of that is that a lot of times the chair will say, we got 5 people, you 2 alternates can go. Well, if you got 4 things on the hearing, on for hearing that night, at the beginning, the chair, through the program we've got here, the way the way it's spelled out, the chair will ask if there's anybody on the board who feels like they need to disqualify themselves. But party, they may wait till their hearing to object. And if the alternates are gone, you can't put anybody new up there. And sometimes it's a procedural game that applicants will play that make us have to deal with a hearing 2 months in a row. Or in a shorter period, we might have to have a special meeting to address it, depending on various situations. But just my thought on it is that for that reason, and for the reason that you learn how things work, particularly with a new group of folks, it's worth coming. If you are the alternate, if you are an alternate who is not sitting, you need to, once once told that you're not going to be the sitting alternate, you need to go in the audience so that people aren't confused and thinking you're making decisions or being involved. But if you don't leave and something comes up as an objection later that recuses somebody else, you may end up back on the board to sit at that time. But you just don't want to confuse people about who's making the decision at the time the decision's made. That's most of what I have.
Ben, can I make a comment?
Sure.
I was lucky enough to sit in on 3 hearings this past year, but being new myself, the guidance, I think, is the biggest thing. Even Donna, who's experienced, we had all sorts of questions for different things, but I think people are concerned that they're not quite sure what the question is that they can ask, and trying to make it make sense, because certainly the subjects were varied. Mm-hmm. I think guidance is really, really important. That's one of the reasons when I said I really don't feel like I can be a co-chair. I don't feel like I've got enough experience to be able to make those decisions, even though you say it's not really a lot of responsibility, but I think it is. So I think your guidance is really important.
I appreciate that. It comes from just
sitting next to you,
getting paid to come to these hearings over years and years and years. If you've been coming to as many as I've come to, you probably know more about it than I do. But on that issue, at any time in a hearing, if you're not sure if what you're getting ready to do is appropriate or not sure how to ask something, you can ask the chair to ask me something. You can just ask me directly. If it's something that I'm not able to answer, like if you ask me, well, how do we vote on it? What do I do? What's the answer to this? I'll nicely tell you that I can't do it. Can't tell you. But if it's something that I can provide any guidance on, I will do my best to do that. I don't want you to be that's what I'm here for. I'm here to be, I guess, kind of a sixth mind as part of the board that has some continuity from years and from experience. I've been representing this board since 2008. I represent the town of Southern Shores. I represent the town of Hertford. I do work for all the towns on the beach. I've appeared at boards of adjustment and boards of commissions all over the place. So I've got a decent background in how this stuff works. But I will tell you that just about every question surprises me in some way or fashion. But having the background lets me go and kind of analogize it to something else and try and come up with a resolution, or knowing where to look in the statute or knowing where to look in the ordinance to try and answer your questions.
I have a question, just
Sure.
procedurally. So when the board is making a decision, just reading at some of the past events here, they seem complex, very detailed, and I kind of had to read through things several times to try to feel like I had a handle on things. You're making decisions. Is it a closed session, open session? Do we just
It's all
the testimony and then you vote at that point?
Well,
Is that correct? Because it seems to me like I just
There is
I need to kind of think about that. And
there is the rare ability to have a closed session for this board. You'd want me to guide you for that. But 12 years of being an attorney, 9 years of representing this board, Board of Adjustment, I don't think I've ever gone. I might have done it once here. Well, I think we did it one time here because the judge had sent something back, so I had to. And see, that was one where I wasn't even here, so I didn't do that one. Sometimes I have to. In that case, I was thankfully recused since they got to stay till 2 a.m. I think for that one. But sometimes I won't be the attorney because our firm may represent somebody involved or have some other conflict that it's not that I can't be the attorney. But there will typically be an attorney with the board who will be somebody else. But a closed session is very, very, very rare for a board of adjustment. Almost everything you're going to do is going to be open. The only time I can think of a closed session that would likely come up is if a judge sends something back and there's something about the order that says what you have to do and that I might need to talk about with you.
Support from the judge, and we didn't have it now.
Yeah, so in that case, but even then, it's not uncommon to talk about that. When in doubt, do an open session and nobody has any complaints. There's not much that y'all have. There may be something getting ready to come up that y'all will have some closed sessions. Another thing I can explain is that your decisions don't go to the Board of Commissioners. So if somebody, either the county or the applicant, has an issue with the decision you make, it goes to the Superior Court. And if it's the applicant, then the party that fights with the applicant in Superior Court is the county. If it's the county, the parties that fight with the county in the Superior Court are the applicant and us. And in that case, it really depends on a number of things how that works out. But if the county is the one unhappy with your decision, then the Board of Adjustment gets named as a party, and in most cases I'll probably be the one to appear on behalf of the Board of Adjustment in that proceeding. But there may need to be closed sessions where this board makes some decisions about how I address that proceeding. And that historically has not been something that's come up, but I have a sneaky suspicion that it's getting ready to be something that's going to come up.
Yeah, and we get an opportunity to read the package ahead of time, and we certainly had sufficient opportunity to question everybody, the attorney, Ben, whoever was appearing before. The trick was figuring out what kind of question to ask.
Yeah.
I think that's why I said the comment about the guidance. You kind of know because of your experience and what you do, where you're coming from, and then I think that's why it's such a good that it's a variety of people and backgrounds. But we really had an opportunity to ask questions.
Yeah, and that's part of the process.
And make mistakes, but ask questions.
Yeah. Is that
questions, wrong questions.
Yeah, exactly.
Yeah, is that another thing that makes it like a courtroom is the applicant gives testimony and the county gets to ask them questions. The county staff gives testimony and the applicant gets to ask them questions. And that's one thing that I occasionally raise my hand and remind people of, because sometimes, the chair will let somebody sit down before the other side gets to ask them a question, and you got to let the other side have their shot at them. It's just like a courtroom; everybody gets cross-examination. Now, the other thing that happens in Board of Adjustment hearings is Board of Adjustment hearings have the unfortunate designation as a public hearing. So, in different arenas, public hearing means different things. I think that theoretically, a Board of Adjustment public hearing means it's a hearing that's done in public, but not a hearing that the public gets to speak at, just like at the Board of Commissioners where they get to come up and speak. However, my theory doesn't match the majority of boards' practice, including this board. This board typically allows public testimony. And if you allow somebody to testify who's not one of the applicant and staff get to question that person. What someone can do, if they have a sufficient interest in the situation to meet a standard called standing, which if it comes up, we'll have to deal with it. It's too much for me to try and explain tonight, but basically they got to be a close neighbor who's really going to be damaged by the problem. And it's the easiest way to have standing. Then that person can ask to intervene and to be a party. That would be one of those situations where you're going to have multiple parties, not just the county and the applicant. Once they're a party, my position is they're on the list of people who get to ask questions. But if they don't meet that standing requirement, if they're just a member of the public, they get to talk and they get to be questioned, but they don't get to ask questions and they don't get to make argument at the end of the hearing, like lawyers do when they do their closing statements and wrap things up. So that's something that will come up. The public will come up, and this board typically allows the public to come up. Some boards limit that either by actually cutting people off and saying that's just not relevant to the issue that's here if what they're doing isn't relevant. Or the better way, I think, is to tell them ahead of time, this is the opportunity for public hearing. You're going to get to come up and say, but what you're talking about needs to be relevant, competent evidence that relates to the matters at issue in this case. Because what you'll have is somebody will come up and complain about who knows what if they get an opportunity to speak. But you want them to focus on, somebody may be able to provide, staff may have, a notice of violation where they couldn't get on a property to get good pictures, and they've got really pictures that may or may not show what they want to show, but they're pretty sure something's going on. And then somebody may pop up out of the audience who says, well, I got great pictures. It may be a case that somebody in the public actually has real evidence that's real useful. Now, oftentimes, that person will bump into somebody from staff, and staff will have them over here and call them as a witness, or Ike would call them as a witness, Mr. McCree, or the applicant if it helps the applicant. It's just like where you have a case in court. If somebody tells you they saw something and it helps you, you're going to have them testify for you. But sometimes that person doesn't tell either party and just shows up and says, I got some more facts. And it may help with your decision. Although, honestly, it's pretty rare. Most of the people that come and speak at the public hearing portion of Board of Adjustment hearings just are unhappy and want to have an opportunity to tell you about it. But you get to ask them questions. The parties get to ask them questions. If there are attorneys involved, they'll take a lot of the burden off of you on questioning. If there's something important that one side wants to hit at the other side about, the attorneys will do it. And the attorneys will argue to you. It makes my job and your job a lot easier most times if there are attorneys for both sides here. Because they guide, their job is to guide you into the right area of what your question is, and they can tell you what they think the answer should be. Because that's their job, is to advocate what they think the answer should be. So that makes it so I don't have to guide you as much, usually. But long answer to a short question.
I have a question. I know that we can't put a limitation on the attorneys or the applicant, but there can be a limitation of time on witnesses or everything.
Not a direct time limitation like the Board of Commissioners does for public hearings. The Board of Commissioners has a public comment period, and they probably, know, 3 minutes, 5 minutes?
3 minutes.
3 minutes. So they got a little timer, and you can't do that for a quasi-judicial hearing. But what you can do, if somebody's not on point, not telling you something relevant, then you may be able to ask them to, what's the relevant testimony here? And my advice on it usually is it's better to let them talk. You're less likely to have any issues if you let them talk and let them sit down than if you get in a fight with them about it. But sometimes you got to get in a fight with them about it. And I had a hearing in another county where I was representing their Board of Adjustment, and there was a gentleman that, nice guy, bright guy, had no idea what he was doing in terms of being in front of the board, and wanted to fight about the merits when the question was completely something different. And after the chair asked me, what can I do? I explained it to him. The chair talked to him, said, you need to talk about this. He didn't do it. He didn't do it. He didn't do it. And the chair finally looked at me and said, can I do anything? I said, yeah, tell him to sit down. Told him to sit down. But, again, the easiest thing is to let them have their say. Usually they'll sit down, and it won't take as long as you think it will, particularly the public comment. It's pretty rare that the public end of it is too long. And then the long stages are going to be your staff testimony and your applicant testimony, and usually those are somewhat relevant. The most irrelevant stuff you're going to get is usually going to be from the public comments, but it's just pretty rare that they go on for very long.
Wasn't there some discussion about having the public comment first rather than making them wait until the end? Wasn't it?
That was probably a Board of Commissioners discussion.
Okay.
Do they have to be sworn in for public comment?
Yes. Everybody who testifies to this board needs to be sworn because you're considering facts. I handed out 3 different sheets, and what they are is the sections of Chapter 2 that relate to the Board of Adjustment, which is the one with 2.5 at the bottom right. Variances, the one at 2.61 at the bottom right. And appeals, the one with 2.69 at the bottom right. They don't cover much different than what we've already talked about, but they're worth reading through. In particular, the variance one on page 2.62, section D lists out the Currituck actually goes with 6 standards instead of 5. Instead of the typical 4, but it lists out the standards for that you'll have to vote on to grant or deny a variance. The only other thing is that, and it mentions in here that you can put conditions on a variance. So there may be an occasion where putting conditions on a variance is something that someone wants to do, and we can deal with that when it comes up. But it is something that's available to you. Anybody have any? I can give you a little bit of background about how a hearing works. I think we talked about it a little bit already, but staff will usually give a presentation. Staff doesn't have the burden of proving anything typically. It's usually the applicant. So in a courtroom, the person with the burden usually goes first because they got to put on the facts, and the other side might not want to put on facts that the applicant may fail to put on to support their case. But what you find with the Board of Adjustment situation is that oftentimes the applicant is here without an attorney or without any help or without anybody who knows what they're doing. So it's very useful for everybody to have staff go ahead and go through and kind of give everybody an idea of what's going on. And Currituck staff is also very they have their perspective on what the answer should be, but they're very fair and neutral in their presentation of the facts typically, to the point that, I think that folks who have been here could say that, usually the applicant isn't unhappy. There are occasions when the applicant is unhappy with the staff's testimony, but usually the applicant and the staff kind of agree to disagree and get along, and that's because the staff is pretty fair and neutral about how they present their perspective, which clearly has to differ from the applicant or they wouldn't be here. So the staff will do that. The applicant will have a chance to question whichever staff members testify. Then when the staff's done with their presentation, then the applicant will stand up and have theirs, and we'll be able to call witnesses, and everybody who testifies will get questioned by Mr. McCree if he's here, if he has any questions, get questioned by the board. Sometimes staff asks questions. Sometimes I'll ask for permission to ask questions. And typically, if I'm doing that, it's because I see a couple possible ways something can go, and there hasn't been an answer to something that was put in the record that would be necessary to support that direction. So sometimes I'll make sure that a question gets asked that gets the right information in the record so that you can consider it. But it's pretty rare that I ask questions. And then once everybody's done with that, you'll have the public portion where anybody can come up and speak if they want to. And then they get questioned by both sides, by the board. And then at the end, if there's attorneys, typically you'll have attorneys give a closing argument where they wrap everything up and tell you their perspective on what you should do. If there's not attorneys, what you typically find is that the applicant, instead of really testifying to evidence about what he sees, he's going to tell you that as soon as he stands up. This is what you should do. There isn't necessarily a need for a closing because their evidentiary portion is going to be pretty much their argument and their evidence at the same time.
Can you ask questions during the closing portions?
Yeah.
Board
I
member?
mean, I think if you had to look at it very formally, you typically close the evidentiary portion and formally want to reopen it to ask evidentiary questions of sworn people. But it's not it's not uncommon for the questions to get asked and for people to come up and testify. And unless there's an objection by another party, I think it's fine. If there's an objection, then the answer is to look at me and I'll guide you through by saying, okay, make a motion to reopen the hearing. Okay, we got the hearing open, now ask them the question. Now close it again. And most of the attorneys probably aren't going to object because they're going to know that it's something that we can get around that will take everybody's time unnecessarily to do that. And there's a little bit of back and forth cordiality, I guess is the easiest way to put it, between the board and people who are up here. It's kind of got a small feel, so it's not uncommon to see things like questions at argument. The attorneys aren't testifying; they're not under oath. But somebody may still ask them a question about, well, how do you take that position? You're telling us to analyze the ordinance a certain way, and I don't understand that. And most of the time they'll be glad to answer. And that one of the last topic on what you do when you're reading the ordinance is you're trying to come up with the intent of the people who wrote it. And that doesn't mean usually, like 99.9% of the time usually, that does not mean that you care what somebody that you talked to was a Board of Commissioner at the time, or because you were a Board of Commissioner at the time, or because you were at the Board of Commissioners meeting at the time. You start with what's written on the paper, because that is the clearest expression of what they meant. And if what is written on the paper is not what they meant to mean, they need to change the legislation because you're stuck with it. And that's what guides you, though. Now, sometimes what's written on the paper might have multiple interpretations, and that's where it gets more interesting. And again, that's where you hope that there are lawyers here who can guide you in, this is how you should interpret it my way, and this is how you should interpret it my way. and then you get to decide which one of them is correct. But what you sometimes see is someone who comes in and says, I went to all those hearings, they were talking about that for 22 years, and I read about it in the newspaper. I think what they meant to say when they said 2 feet was 8 feet. Well, no. It says 2 feet. That's what we're all stuck with. If they meant to say 8 feet, they should have put 8 feet in the ordinance. Of course, it's usually not going to come down to a number like that, but if there's any question. But that's what you run into is you got to start with the language before you go out to broader stuff, rather than look at broader stuff and come back to the language. Any other questions?
Someone's gonna have directions word for word, what I say, right?
The county's pretty good about doing that, and
The script, I gave you another script for the next meeting.
How you did?
I gave it to everyone. I think everybody should have
We got a
of it.
copy.
It's a front and back page. And it says
Suggested procedure for chairing a meeting.
Yeah.
and then at the end of the meeting, somebody just needs to make a motion to adjourn, and then somebody will second that, and then if you're still here afterwards, then you voted against it.
But that's all right tonight.
well, there's two. One
We'll check the 12th of October on it.
Yes.
All right, I'll show it to you.
I have another.
I see, I see it. Okay. And that's all I have to say for certain.
We'll see. Yeah, I mean, I think that that's what they've had historically is a pretty good guide for starting. But I mean, things come up, things change depending on different situations. Yeah, I'll do my best to help guide you through that. That's part of why I'm here.
Either I'm on the bathroom break.
And sometimes, I said there's no closed session, so a closed session would be something where the whole board is in there, but it occasionally occurs where somebody has their own individual question that they don't want to ask me in front of everybody initially. And one way to do that is to ask the chair for a recess, and then just ask me without the rest of the board. It's not a meeting then, it's just you asking. Most times that's unnecessary. It's fine to just ask in open session. But I've had that come up. And in your situation where you're talking about procedure with the chair, sometimes that comes up more. That's probably the most often time that it comes up. Sometimes the chair may feel uncomfortable showing any sort of weakness in front of the audience. So they may ask for a recess or something to ask me a procedural question. But usually, I think you saw Mr. Palmer and I guess Mr.
Yeah, they did a great job. I don't think I can tolerate it.
I think you'll be fine, but they didn't hesitate to typically just ask me questions in the open session.
I'll make a motion to adjourn.
Second.